So this We the People news. Alright. So this video is more of an idea of how we in generally lost our sovereign rights for sovereign people, okay? And men's rights, men and women's rights, okay? As due to the 11th Amendment of sovereign immunity. So way back in the way back days, kings have sovereign immunity. They gave themselves. Imagine that. So the state somehow has magic powers. It's a corporation or a government entity, but it's still a place or a thing that gave themselves some type of sovereign and not alive. Alright, so Article 3, and he'll discuss Article 3, the three things in Article 3, which was all equal. And the states that owe a debt did not want to pay their debt. So, they decide to go ahead and claim sovereign immunity. And so, when the government says there's no such things in the United States as sovereign or this out here, okay, well, they describe the true definition of the state. And they cannot have us equal to the state. We must be subjects and beneath the almighty King of Texas or the mighty King of Judges.
The topic that I'm going to begin with is the topic of sovereign immunity. So return with me to Europe back in the good old days of totalitarian monarchies. Justice emanates from the crown and you can't sue the king. That would be nonsensical, justice emanating from the king. The king being the fountain of justice can't be susceptible to his own adverse decisions. This doctrine, which developed over centuries.
I can honestly say, y'all, when the kings gave themselves sovereign, but they truly cannot be sovereign. Why? Because the people can make him lose his head. So how can he be truly sovereign if the sovereign can be taken away? And how can we lose our sovereign if it cannot be taken away? Just saying.
It's in Europe. It's called sovereign immunity. The sovereign is immune from the judicial process, from judicial liability. It's a doctrine that one would think would have been offensive to the founders of the Republic, and I'm sure it was to many of them, yet it's a doctrine that on forming a new country here, they chose to adopt. So sovereign immunity crosses the Atlantic. Sovereignty is vested in a different authority in the United States. It's the people who are sovereign, but the people can't be sued. The United States is immune from suit, and that's just how it is, unless it is willing to waive its immunity and allow itself to be sued. Now that's the federal sovereign immunity rule. It's not in the Constitution. It's arguably grounded in the structure of the Constitution, but maybe it's more properly located in federal common law. There are two other sovereigns operating on the lands that the United States occupies. The tribes, the native tribes, are sovereign, and they also enjoy sovereign immunity as a consequence of arguably international law, but maybe more expressly federal common law. And then the states, and it's the states that I want to focus on, because the issue of state sovereign immunity is something that the founders actually talked about in the Constitution. The susceptibility of suits to federal judicial process is arguably covered in Article 3. And so we have constitutional law on that topic. We've got a fair amount of discussion, and we've got some interesting history. I want to share that history with you, and then I want to let you know where we are today. So return with me now to 1777. We're at war with the British. Georgia has an army. but they don't have a whole lot in the way of supplies. And the state of Georgia, the newly independent state of Georgia, contracts with a South Carolina merchant named Robert Farquhar to...
It was contract, y'all. That's above sovereign.
Provide a variety of goods that Georgia needs to prosecute the war effort. The deal is a paper deal. The goods arrive, and Georgia says, "Yeah, we'll pay you. Don't worry, we're good for it." And 1778 rolls around, and 1780, 91, 92. Independence is won, or into the 1780s. New constitution, new government. Robert Farquhar is Georgia. Remember me? You owe me money for that stuff from the war. Yeah. We'll get around to that, and eventually Farquhar dies. Decades pass. Nothing comes from Georgia, and his executor, a guy named Alexander Chisholm, decides that he's going to file suit against Georgia, or to do something to attempt to recover this debt so that it can be paid into his estate and distributed to his friend Robert Farquhar's heirs. Now, can he sue? Well, nobody had ever really asked this question before. This isn't the only unpaid Revolutionary War creditor, mind, but it's the first to ask the question, well, is there some way I can use the new federal courts established by Congress pursuant to constitutional directive to get this money out of Georgia? And so we took a look at Article 3 of the Constitution, which establishes the federal judiciary, and it says that the federal judicial power shall extend to, controversies, it says, between a state and foreign states, citizens, or subjects. So,
right there, people. So think about that. We was all equal. We was allowed to go after one another if there was harm done. There had to be a remedy. A remedy.
Okay, so that sounds like the state of Georgia and me, right? I'm Alexander Chisholm, citizen of a different state, South Carolina. He's a South Carolinian like Farquhar. So we file suit. The Supreme Court gets this case, and Georgia says, "What? How you can't sue us? We have sovereign immunity." And Chisholm says, "Yeah, but it says." And so it wasn't this copy, but it might have been, right? A little copy of the Constitution. And so the court says, "Well, I don't know. Let's read the language." And 4 of the 5 justices decide that Chisholm's right. That in fact, the federal judicial power does extend to suits brought by citizens of other states against states. So they entertain the action, and Georgia is very unhappy. Now, it's not just Georgia that's unhappy.
All right, sit and think about that, y'all. The people won. Our individual rights won this lawsuit.
About this. Other states that owe money are unhappy about the prospect that they're now going to be sued by all of these Revolutionary War creditors. And so they rally. And it's almost the first great interstate rally since the Revolution itself. And it's a rally in favor of the 11th Amendment. This is the first amendment since that first group of 10 was pushed through by the first Congress in 1791. And the 11th Amendment says, here's the deal. I'm going to paraphrase it, then I'll read it to you. Here's the deal. That business about the judicial power extending to suits between states and citizens of other states, that wasn't meant to include suits where the states were the defendants. It was only supposed to include suits where the states were the plaintiffs. So Georgia can sue this guy Chisholm, but Chisholm can't sue Georgia. And
see, y'all, the trickery of words. Everybody knew what the tent was, but they had to throw that trickery in there, right? So therefore, since the government is not overpowering we the people, this 11th Amendment, even by the Constitution standards, that Congress cannot give themselves more authority than they already have. guess what? By this 11th Amendment, they gave themselves more authority than they do not originally have. So the 11th Amendment is actually technically unconstitutional.
Here's how it's written. The judicial power of the United States, and it's adopted, right? So the language reads, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state, and they threw that in because there were a lot of European bondholders too, right? So individuals now from other states, individuals from foreign countries can't sue states, and everybody relaxes. Well, everybody being the states relax because now they're no longer going to be liable in federal court to suit for payment of these debts on which many of them have defaulted. That's Chisholm versus Georgia and its result. 1793 is the decision. 11th Amendment is passed almost immediately afterwards, and then time passes. Now, the Civil War comes, the Civil War goes, we're into the Gilded Age, and a fellow named Hans in Louisiana has bought bonds from his own state, from the state of Louisiana. And Louisiana, economic difficulty, rewrites its constitution in the 1870s, 1880s, and apparently decides that it's not going to pay out on these bonds that Hans has purchased. So Hans says, well, I'm going to sue him in federal court. And presumably someone suggested, well, I don't know if you can do that because the 11th Amendment. Hans says, yeah, but the 11th Amendment says you can't sue a state if you're a citizen of a different state or a foreign country. It doesn't say you can't sue your own state in federal court, so he files suit. That case, Hans versus Louisiana, gets decided by the Supreme Court in 1890, and the Supreme Court says, wow, you know, technically Hans is kind of right on the money. That is what it says, but in our view, and this is the majority opinion, the reason that the 11th Amendment didn't expressly prohibit suits by citizens of states against their own state is that everybody assumed that that would be the rule. So even though it doesn't say it, we're going to read that restriction into the 11th Amendment. So the 11th Amendment now says judicial power shall not be construed to extend to suits prosecuted against one of the states by citizens of other states, citizens of foreign states, or citizens of your own state. That's slipped in by the Hans versus Louisiana decision. All right, so time goes on, and there is a First World War. And in the course of the First World War, a lot of federal money goes to support warring European states, including Great Britain. And when the war is over, it's time to pay this money back. And a lot of these British bondholders the British government included, but individuals in Britain too, who are going to be indirectly through taxation liable to contribute to the repayment of this American war debt, say, you know what? We owe the Americans money for the war, but they owe us money too. And what they had, these things started appearing out of attics, were these old pre-Civil War state bonds, just like we're talking about, but these are ones that had been sitting in European attics for generations, and they had been issued by lots of states, including southern states in the years before the Civil War, and then the states had repudiated them. Now, Mississippi was especially notorious for this, and this is a case that's going to give rise to our final Supreme Court decision in this line. Mississippi in the 1830s, as a lot of states, had gotten really enthusiastic about economic development, about banking, and they had chartered two banks, the Mississippi Planters Bank and the Mississippi Union Bank, and then they issued state bonds to raise money to capitalize these banks. They sold $7 million worth of bonds, which was a lot of money, and most of them were bought by Europeans, many by British speculators, hoping that the Mississippi banking industry would really take off. Well, it didn't. 1837, there's a financial crisis, and practically all these things went bankrupt. including these two Mississippi banks. And then the Civil War came. These bonds weren't payable until some 1861, 1865, issued in 1830. A lot happened, turns out, between 1830 and 1865 in Mississippi. And so when the war was finished, the state of Mississippi expressly repudiated these things. We're never going to pay on these bonds. And European bondholders felt stymied and frustrated. The 11th Amendment prohibited them as individuals, or rather from bringing suit. Individuals in the state couldn't sue because of Hans versus Louisiana. Individuals in other states who held these bonds couldn't sue. So what's a bondholder to do? Well, this repayment obligation for the First World War debt combined with the Great Depression inspired some real creative lawyering. And what a group of bondholders finally decided was, okay, here are the restrictions. The citizens of states can't sue, citizens of foreign states can't sue, citizens of foreign countries can't sue, but there's nothing in there prohibiting foreign countries from suing. So they collected a bunch of these bonds, worth in the tens of thousands of dollars, old Mississippi Planters and Union Bank bonds, and they carried them to the American legation in Paris, 1934, end of September 1934, and they handed them over to the government of Monaco, of the Principality of Monaco. And they said, we give these to you outright, no conditions, do what you will with them, they're all yours. So the Principality of Monaco took these things and immediately filed suit against the state of Mississippi in a federal court. And the thinking was this would get around the problems, the 11th Amendment limitations and the Hans versus Louisiana limitation. Now it's a foreign country suing a state on these bonds, and surely that will be effective. Mind, this would have provided a platform for other countries to do. Everybody could have handed their bonds to Monaco and said, now do ours, right? And eventually Mississippi might have been forced to repay them. All of these things, the Supreme Court got this case in 1934, Monaco versus Mississippi, and decided, this doesn't seem right either. So Hans versus Louisiana, we inserted citizens of foreign countries. Monaco versus Mississippi, we're going to go ahead and insert, and foreign countries can't sue states in federal courts either. So we've had a judicially greatly expanded 11th Amendment scope of immunity. Now effectively it reads that suits, federal judicial power doesn't extend to suits brought by citizens of your own state, other states, foreign states, or by foreign countries, any suit in law and equity. Now, that doesn't leave much, right? That doesn't leave much. How in the world do you sue a suit if you think it's done wrong? And not just in not paying bonds. How do you sue a state, or how do you get a state to abide by the federal Constitution if you think your constitutional rights have been violated? Because this is the federal judicial power. Federal courts ordinarily have jurisdiction to police the Constitution, but we can't bring suits because of the 11th Amendment. Well, there are three ways. There are three things that can happen that get us around this expanded 11th Amendment problem. The first is that the United States can sue. 11th Amendment doesn't bar suits by the United States against states if they've violated constitutional requirements. The second is that states can waive their immunity. And that actually happens more than you might think. The federal government does too. There are two big statutes at the federal level, and they're state mirrors. One's the Tucker Act, which is a statute that waives federal sovereign immunity for government contract lawsuits. So you contract to sell pencils to the federal government, they don't pay you, you can sue them, right, under the Tucker Act. And then the Federal Tort Claims Act, that's if you get run over by a mail carrier, you can sue if there's a tort that's been committed. And most states, probably all states, have things like that. But that doesn't necessarily help you on constitutional claims. So the last answer, and this is probably the most important, certainly for constitutional law purposes, is a 1908 Supreme Court decision created exception called Ex parte Young. Edward Young was the Attorney General of the state of Minnesota, charged with enforcing allegedly unconstitutional state railroad regulations. And the railroads couldn't sue the state because of the 11th Amendment, but they thought, maybe we can sue Young, and so they did. So they filed suit against Young, seeking an injunction, a court order, federal court order to him to stop enforcing these unconstitutional state laws. And the Supreme Court took that and thought, we really haven't left folks many ways of challenging unconstitutional action by states. So let's go with this. And the Ex parte Young rule since 1908 has been the principal mechanism for filing constitutional claims against state governments that you believe have violated your constitutional rights. You can't sue the state. You can't sue for money, but you can sue a state official for an injunction to get him or her to stop enforcing what you believe to be an unconstitutional state act. Thank you.
So, let's see. We're going to go ahead and give you this opening to sue us. However, you're not going to get your money back for the money you spend for the unconstitutional violation I caused you. Alright, just like I told you guys before, and before this and this and this, right? If my neighbor right beside me is sovereign, and I'm sovereign, then me and him can't go after one another unless I've committed a harm upon another sovereign, or vice versa. If my neighbor beside me is a man, and I'm a man, I cannot go after him because of same principle. Everything's the exact same principle. Okay? So the 11th Amendment really went in there and destroyed our freedom at the foundation due to not paying their bills. Alright? To get out of debt. Sit and think about that, y'all. A man loaned the state money and then created an amendment and say, we don't have to pay you because we're sovereign, even though you're supposed to be a sovereign man. Now, that being said, they never brought up the sovereign man part. Okay? So, therefore, there was no equal footing in that case, but it should have been the intent. Right? And again, I don't know. You guys decide on that. Alright? But my opinion, and it's not legal advice, my opinion, the 11th Amendment is null and void due to they're not supposed to have more power. When they have supposed to create a new constitution, or a new like a 12th and 13th and all that, is to actually technically to release power, not to gain power. That was the intent. And like this guy says right here, they keep on bringing this assuming thing. Well, that's a colorful word, right? I don't know, y'all. You guys decide. This is We the People News. Bye, y'all.